This is 106.7, Wilmington's Big Talker, and my name is Paul Vallone. I'd like to welcome you to Guns, Politics, and Freedom, where each Sunday at 5 p.m., as part of the Sunday Night Political Power Block, we give you the ammunition to better defend your gun rights. Now, in case you aren't familiar with me, I direct Grassroots North Carolina, or GRNC, since 1994, our state's most effective gun rights organization. As its director, I was involved in drafting and passing our original concealed handgun law back in 1995. Since then, GRNC has gone on to engineer the passage of concealed handgun reciprocity, our purchase permit bypass, castle doctrine and stand your ground, the expansion of concealed carry into state and municipal parks, restaurants, public assemblies, educational properties, and much more. Grassroots North Carolina is exactly what the name implies, a grassroots collection of people from all walks of life who share a common concern that our constitutionally guaranteed freedoms are being eroded. Check us out at grnc.org. That's grnc.org. Our topic today is the Second Amendment in the courts. What comes after Heller? And we are fortunate to have Campbell University Law School professor Greg Wallace, who teaches constitutional law with an emphasis on free speech, church and state, the right to keep and bear arms, and constitutional interpretation. He frequently providing commentary on constitutional issues at conferences and symposium, as well as news reports, talk radio, and op-ed columns. Professor Wallace is a regular contributor to thehill.com. Welcome, Greg.
Thank you for having me. It's great to be here.
After the Supreme Court ruled in D.C. versus Heller that the Second Amendment does indeed reinforce an individual right to arms, many gun rights supporters figured we would be on easy street, but that has not been the case, has it?
The Supreme Court took up another Second Amendment case shortly after Heller, because Heller had to do with a challenged firearm restriction in the District of Columbia, which is a federal enclave. The court did not have the occasion to determine whether the Second Amendment should apply to the states. In the McDonald case in 2010, the court did say that the Second Amendment is a fundamental right that is so important that it ought to apply to the states, just like the rights to free speech, the right to freedom of religion, the right to be free from unreasonable searches and seizures, the right to not have to be compelled to give testimony against yourselves, other parts of the Bill of Rights. And the court specifically noted that the right to keep and bear arms is not a second-class right, and yet that's exactly what the lower courts, since the Heller decision, we're coming up next year, will be the 10th anniversary of Heller, and since the Heller decision and the 2 years later, the McDonald decision, the lower courts have not treated the Second Amendment with the same regard as other protections, other guarantees in the Bill of Rights.
Imagine that, lower courts disregarding the Constitution. I can't imagine such a thing, nor imagine could Donald Trump. Now, in fact, we've had a number of cases that essentially the Heller decision established the right to keep arms in the home. Would that be a fair statement? It
Yes.
really did not address bearing arms outside the home.
No, it was the facts in Heller concerned a D.C. restriction on keeping a firearm, a handgun, in the home. Now, Heller did talk about the meaning of bear arms, which would suggest that the right to keep and bear arms, this right to keep and bear arms primarily for the purpose of individual self-defense, as Heller emphasized, was not confined to the limits of the home, but the facts in Heller itself only addressed a regulation that prohibited handguns in the home.
I see. Okay. So since then, there have been a number of efforts to try and expand the Supreme Court interpretation of the Second Amendment to include bearing arms outside the home. And I'm happy to say our organization, Grassroots North Carolina, was involved in one of those efforts. Where Alan Gurra was arguing Bateman versus Purdue. Alan contacted me even before the McDonald decision came down and said, you have a wonderful law here. It is a blanket ban, or a wonderful law to serve as a test case, because it was a blanket ban on carrying firearms outside the home during states of emergency. Can you tell us a little bit about that case and how, unfortunately, it never became precedent-setting law to the Supreme Court?
Well, the case was decided by a federal district court here in North Carolina, and the federal district court said that such a blanket ban on carrying firearms outside the home was overly broad and violated individuals' rights to keep and bear arms under the Second Amendment. And so shortly thereafter, the state legislature redrafted the law to make a specific exception for those who legally owned firearms. The state of emergency still can be invoked and prohibit illegal types of firearms or other dangerous explosives or things like this during a state of emergency. But under state law now, after the Bateman case, the government cannot deprive you of the right to keep and bear arms outside the home during these states of emergency.
I should note that the first thing that we'd actually hoped to lose because we wanted to see this go to the Supreme Court, but unfortunately, after we won on Second Amendment grounds, the state of North Carolina and Governor Perdue chose not to appeal the decision. So unfortunately, it never went any further than that. I can assure you, however, that I was very much involved in repealing the then unconstitutional state of emergency gun ban, and it was anything but easy because the General Assembly was quite happy to replace the unconstitutional gun ban with another unconstitutional gun ban, and had to be beaten about the head and neck rather soundly in order to remove them, to pry them off this concept. And ultimately, they did the right thing, but only reluctantly. So as it stands right now, we are, thanks to Bateman versus Perdue, you may carry a firearm for self-defense outside your home during declared state of emergency. Other ones that come to mind are Moore v. Madigan and most recently Peruta versus California. And Moore versus Madigan was another case that was supposed to be on bearing arms outside the home, and as is Peruta, and the Supreme Court has picked up neither of those.
What the states have done after the Heller decision is to pass laws. Certain states have passed laws that say that you cannot carry a weapon concealed outside the home unless you have a special need for that goes beyond the simple general risk to safety that people have in the public while they're moving about. And these laws have generally been upheld. Now, in the Moore case, the Seventh Circuit early on after Heller, of course, the McDonald case was a case out of Chicago dealing with restrictions that the city of Chicago had imposed. Very interestingly, Chicago has some of the most restrictive gun laws in the nation, and yet it hasn't done much to reduce the gun violence there.
Most would argue quite the opposite,
yes.
Actually.
But after McDonald versus Chicago, you had some cases in the Seventh Circuit that seemed to suggest that the lower courts were going to apply Heller very vigorously, and Moore versus Madigan was one of them. In that case, Judge Posner wrote that even though this was a case of first impression with respect to the application of the Second Amendment outside the home, if the Second Amendment is indeed there to allow people the right to keep and bear arms for the purpose of self-defense, which is exactly what how the court interpreted Heller in the McDonald decision. He says if that's the case, then people are going to need firearms for self-defense outside the home as well as inside the home. In fact, he says in many instances the risk of having someone confront you and put your life in danger is greater outside the home than inside the home. So you take both the language of Heller, or the language of the Second Amendment, the right to keep and bear arms. Bear arms doesn't mean just simply moving from your bedroom to your kitchen with your handgun. It would suggest certainly that it is a right that is to carry in public. And then the Moore versus Madigan said, well, if you tie that in to the underlying purpose for the Second Amendment, which was identified by the court in Heller as being primarily for purposes of self-defense, then you're going to need to bear arms in public for self-defense. Mm-hmm. So that signaled a pretty good direction, but after that is where the lower courts began to go awry.
I see. Okay. And in a moment, we'll pick that up, and we're going to pick up with the Fourth Circuit in Virginia, which has direct bearing on us, as we will see right here in North Carolina. We'll talk about that shortly. In the meantime, you are listening to Wilmington's Big Talker 106.7, wilmingtonbigtalker.com, and I am Paul Vallone, your host for Guns, Politics, and Freedom. In a moment, we'll take a short break, after which we'll return with Professor Greg Wallace and charting the course of the Second Amendment in the courts. So please join us after the break for the next segment of Guns, Politics, and Freedom. My name is Paul Vallone, and you are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker 106.7, wilmingtonbigtalker.com. Our guest today is constitutional law professor Greg Wallace, and our topic is the Second Amendment in the courts, what comes after Heller. Welcome back, Greg.
Thanks.
Now, we're getting on to the Fourth Circuit, okay, and before we talk about the most recently rejected case by the Supreme Court, the Fourth Circuit Court of Appeals, correct me if I'm wrong, but this covers Maryland, Virginia, West Virginia, North Carolina, and South Carolina, right?
Yes, all the lower federal courts in those states are obligated to follow the rules of the Intermediate Appellate Court, the Fourth Circuit, and then, of course, if cases from the Fourth Circuit can be appealed to the Supreme Court. But if the Supreme Court declines to review those cases, then whatever is the law in the Fourth Circuit is the law here in North Carolina.
So it is precedent setting, and we're going to talk about two cases that are now binding law here in North Carolina. Is that right?
Yes, they are.
Two fairly egregious decisions, as I recall. Why don't you tell us, let's see, I guess the two cases are Colby versus Hogan and U.S. versus Robinson. And I'm happy to say, by the way, that in researching Robinson, the very first piece I came up with was your piece from The Hill. So tell us about those two cases, if you would, please.
Well, let me tie this into what we were talking about in the previous segment. A number of states decided that they were going to restrict concealed carry outside the home by passing laws that denied concealed carry license to people unless they had some sort of a justifiable need, that is, an urgent necessity or a specific threat of danger. The Fourth Circuit in 2013, in the case of Woolard versus Gallagher, upheld Maryland's law to that effect. So the Fourth Circuit joined the Third Circuit and the Second Circuit, as well as the Ninth Circuit, in upholding these kinds of laws. So the Fourth Circuit has not been good on gun rights all the way back to 2013. But this year, just in the last 6 months of this year, the Fourth Circuit has issued three separate decisions on gun rights. The two most egregious are the Colby versus Hogan case and the United States versus Robinson case. Now, the one I'm not going to really talk about is the Hamilton versus Palazzi case, in which the Fourth Circuit held that a former nonviolent felon who had been convicted in Virginia many years ago of credit card theft and fraud cannot raise an as-applied Second Amendment challenge to a Maryland law denying him a permit to possess firearms for self-defense unless he has a full pardon from the state of Virginia. Now, this man, Mr. Hamilton, had his firearm rights restored in Virginia courts and by the federal government. In fact, he's even employed as an armed security agent by the Department of Homeland Security.
Well, there's irony.
And he's had no history of violent behavior.
Did you say by the Department of Homeland Homeland Security?
Yes.
Oh, no.
Again, but he's had no history of violent behavior, and there have been at least 5 previous Fourth Circuit decisions indicating that the court was open to these as-applied challenges to felon disarmament laws, and the majority of other circuit courts allow such challenges, but the Fourth Circuit said no. His rehabilitation is irrelevant unless he has a pardon from the state of Virginia, and the Democratic governor of Virginia is not about to give him a pardon. I was about to say
Terry McAuliffe. Yes. I'm sure he'll be right on that.
So that was one of the objectionable cases too. The other two that you mentioned that I do want to take a few minutes to talk about are the Colby versus Hogan case, in which the Fourth Circuit sitting in bank. Now, when we talk about a court sitting in bank, these appellate courts are made up of anywhere from 12 to 15 judges. In most cases, like the Hamilton case I mentioned, they sit as 3-judge panels. Okay. Now, they can only be overruled by the entire circuit court, all the judges sitting in what we call in bank. Okay. And the first time the Holby case was decided, and it was a challenge to the Maryland law that bans the ownership, possession, and use of so-called assault weapons, the AR-15 type and AK-47 type weapons. The first time that case was heard by a 3-judge panel on the Fourth Circuit, those 3 judges decided that the strictest of scrutiny needed to be applied to that law. Okay. And it sent it back down to the lower court to do that. So it was a very gun rights favorable decision there. But then the state of Maryland appealed to the entire Fourth Circuit. Okay. And all of the judges on the Fourth Circuit came out. And not only and this is not the first time a federal court has upheld a so-called assault weapons ban, but what was different about this case is that in this case, the Fourth Circuit held that the ownership, possession, and use of these kinds of weapons, and along with so-called large capacity magazines, which would be any magazine above 10 rounds, that those
standard capacity magazines.
Standard capacity magazines for AR-15s.
I refuse to use their phraseology. Go ahead.
But the court held that the Second Amendment doesn't protect those weapons or those magazines. We don't even need to get to deciding whether the state has a sufficient justification for the ban. The Second Amendment simply is not implicated when the state of Maryland bans these types of weapons and magazines.
Now, correct me if I'm wrong, but if we go right back to the U.S. versus Miller decision in 1939, I think it was, even that said the only types of firearms that were protected were, in fact, militia-type firearms. And if an AR-15 is not a militia-type firearm, I don't know what is.
But this is why the Fourth Circuit's decision, I think, is so outrageous. It reasoned that because these banned assault weapons are like M16s and are what the court calls weapons of war, they're not protected by the Second Amendment. Now, let me tell you this. There is no military force that I know which uses civilian AR-15s, which, as many of your listeners may know, the big difference between the M16 or M4 that the military uses and the civilian AR-15s is that the military weapons are select fire weapons, which means they can fire on automatic, which means you can pull the trigger one time and either a short 3-round burst will come out or it will continue firing until you let up the trigger. On the other hand, civilian AR-15s, of course, are semi-automatic only. They're not select fire weapons, which means 1 round is shot for every pull of the trigger. But the Fourth Circuit said, well, these are weapons of war, and therefore they are not protected under the Second Amendment. Now that was based on two things. It was based on a misreading of Heller, and secondly, it was based, in my view, on deliberate ignorance of the facts about how these weapons operate.
Okay. And by the way, in terms of how those weapons operate, I'd like to thank you for being not only a constitutional scholar and understanding the Second Amendment, but actually being a shooter who understands how these firearms work. I want you to know that my son, as I'm sure you remember, took your constitutional law course, and he got back to me, and he was absolutely thrilled the day you brought in a bunch of guns to class to show them this stuff and how it works. So we salute you and your hands-on approach to why the Second Amendment means what it does.
Well, one of the things that I tell my students is that it is absolutely ludicrous for people making laws, and I will add judges ruling on these laws, if they have no idea about how firearms operate. And unfortunately, that's the case in most instances. Like the Congress lady from California who sponsored a ban on magazines at the federal level. She thought, somebody asked her, what are you going to do about all the magazines that are currently in circulation? And she thought once you used a magazine the first time, you used it up and you had to throw it away, kind of like a piece of chewing gum. So it's just astonishing, the ignorance. But the problem is that the state of Maryland presented a lot of material and sort of self-serving types of evidence to support its case that was produced by anti-gun rights organizations like the Brady Campaign and the Violence Prevention
Factoids.
Center. Yes, and the court
that's what drives public policy right now. Factoids.
The court took that as face value. Now, the second case, which
I'm going to hold you right now, and when we come back, we will talk about that second case. In the meantime, you're listening to Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com, and I am Paul Vallone, your host for Guns, Politics, and Freedom. In a moment, we will take a short break, after which we will return with Professor Greg Wallace and charting the course of the Second Amendment in the courts, and specifically, I think he wants to talk about U.S. versus Robinson, the other egregious case. So please join us for Guns, Politics, and Freedom.
The ignorance, but the problem is that the state of Maryland presented a lot of material and sort of self-serving types of evidence to support its case that was produced by anti-gun rights organizations like the Brady Campaign and the Violence Prevention
Factoids.
Center. Yes, and the court
that's what drives public policy right now. Factoids.
The court took that as face value. Now, the second case, which
I'm going to hold you right now, and when we come back, we will talk about that second case. In the meantime, you're listening to Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com, and I am Paul Vallone, your host for Guns, Politics, and Freedom. In a moment, we will take a short break, after which we will return with Professor Greg Wallace and charting the course of the Second Amendment in the courts, and specifically, I think he wants to talk about U.S. versus Robinson, the other egregious case. So please join us for Guns, Politics, and Freedom. Case. So please join us for Guns, Politics, and Freedom. My name is Paul Vallone, and you are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com. Our guest today is constitutional law professor Greg Wallace, and our topic is the Second Amendment in the courts. What comes after Heller? Welcome back, Greg.
Thanks for having me.
Now, you were talking about the second egregious case to come out of the Fourth Circuit Court of Appeals, which, as we correctly noted, has precedent, is legally binding here in North Carolina, and this one really has a lot to say to concealed handgun permit holders, does it not?
It does. This is not a Second Amendment case. It is a Fourth Amendment case. Under the Fourth Amendment, we are protected against unreasonable searches and seizures by police and other law enforcement authorities. And the Supreme Court a number of years ago recognized that a person could be briefly searched. In other words, he could be searched by simply a frisk on the outer part of the clothing if the police had reason to believe, not probable cause, but mere reasonable suspicion that the person was armed and presently dangerous. So this because the
two things, armed and
presently
dangerous.
Yes, armed and dangerous. Now, what the Fourth Circuit held in the United States versus Robinson was that a Terry frisk of the outer clothing, as long as the person has been lawfully stopped by the police can perform a frisk on a person who is lawfully stopped based on only on the reasonable suspicion that the person is armed, without any additional suspicion that the person is presently dangerous to the officers or others. And what the court did there was to establish a bright line rule that anyone who is armed is also per se dangerous, even if that person may be lawfully carrying a firearm, and there's nothing to suggest that the person poses a threat to the police or the public.
So you're telling me that I'm presumed to be dangerous even though I am certified law-abiding. I've had a criminal background check by the FBI to get my concealed handgun permit. I've been through the course, laws governing the use of deadly force, laws governing the use of the concealed handgun permit, the whole deal. I am considered to be dangerous strictly because I'm carrying a firearm for self-protection. Is that it?
Yes, the majority of the court, and again, this was another in-bank decision, reasoned that since guns are dangerous, anyone who carries a gun is dangerous, and the police
Hammers
can act.
are dangerous.
That's right. But what it did, from a legal standpoint, is it collapsed the conjunctive conditions, armed and dangerous, into a unitary concept, armed and therefore dangerous, thus stripping the dangerous part of that test from any independent meaning and rendering it a mere redundancy. So simply carrying a firearm lawfully is enough to make you dangerous and subject to what we call a Terry frisk, which would be the police patting you down on the outside of your clothing to see if you're armed, and then if you are, confiscating your firearm. A Terry frisk also applies to the interior of your car. If the police lawfully stop you, and then let's say they run your license plate and it indicates that you are a concealed carry holder, or you tell the police, as you're lawfully required to do in North Carolina when they approach your car, that you are armed, then the police can make you step out of the car, and they can search the interior of your car for weapons as well.
Whoa. Now, hold on while I get outraged here, okay? And I mean significantly outraged. So you are telling me that I'm driving along, okay? I'm driving the speed limit. Maybe I have a tail light out or some other minor traffic, some minor infraction, and they pull me over. Now, under North Carolina law, under North Carolina system, they can run my license and determine that I'm a concealed handgun permit holder. Okay?
Yes.
Not to mention the fact that I am required to identify myself as a concealed handgun permit holder and carrying a firearm. That is by itself now grounds to remove me from the car, pat me down, and search the inside of my vehicle?
Yes, they can search the interior of your vehicle anywhere that a firearm might be found, which means they could look in your glove compartment, they could look under the seat, they could look in the back seat, they couldn't look in small containers.
The Fourth Amendment, as we know it, is dead in North Carolina, as near as I could say from what you're saying.
Well, what's confusing and shocking about this decision at the same time is that the Supreme Court, in stating this case in a number of decisions after Terry, in fact, even if you look at the Terry decision itself, the Supreme Court has described the test as armed and presently dangerous. So the Supreme Court obviously thinks that these are two separate inquiries. Are you armed? And then if you are you presently dangerous? And the police would have to have ordinarily under the Supreme Court test, the police would have to have some reason to believe that not only are you armed, but you are also pose a danger to the police or to bystanders before they could perform one of these Terry frisks. And the Fourth Circuit has collapsed those two concepts into a single idea that if you're armed, then you are therefore dangerous.
Oh my heavens! And so now, I'm stunned by this. Actually, I hadn't really myself considered the full implications of this. I'd heard about the decision beforehand, but I hadn't really stopped to think about what it means to your Joe average concealed handgun permit holder. Now, this thing's a Fourth Circuit decision. Is this under appeal to the Supreme Court?
I don't know whether the Mr. Robinson in this case has decided to appeal it to the Supreme Court or not. I have not had any information that it is.
This is genuinely scary stuff right here. And so, could we address this with state legislation?
No, because this is a matter of Fourth Amendment law, and what the court says. Now the state, yes.
Well, I can think of one way we can address it. We could pull the concealed handgun permit holder information out of the motor vehicle database, and we could stop requiring people to identify themselves to police officers, for starters.
Well, yes, the state cannot change the meaning of the Fourth Amendment by its statutes, but the state can provide additional protections above and beyond. So the state could pass a law which says that state police and local law enforcement officers in North Carolina could not search somebody unless they had reason to believe that he's armed and presently dangerous.
Now, that's something on my radar for the future. You and I are going to have to talk about that one. I'm thinking that Grassroots North Carolina has a new project, because anything else is just not acceptable under the Fourth Amendment or any consideration of privacy whatsoever. Now, we'll start a little bit on this and probably pick it up when we come back. This, I guess, brings us up to the most recent case rejected by the Supreme Court, Peruta versus California. Now, I mean, the Supreme Court just rejected this case, and I thought, I love Neil Gorsuch. I think this guy is wonderful, and I think Donald Trump did a fine job on his appointment. But wasn't this supposed to solve this problem? What happened?
You had the Supreme Court deny review, which doesn't mean that it affirms the lower case. It just decides not to hear it. And there are a number of reasons why the Supreme Court may not hear a case. But Justice Thomas wrote a pretty strong dissent over the court's decision not to review this case. And after break, we can talk a little bit about the particulars of the case. It's kind of unusual about the right to carry in public. But Justice Gorsuch joined Justice Thomas's decision. But I think notably absent was any concurrence from other justices like Justice Alito or Justice Roberts or even perhaps Justice Kennedy.
Kennedy.
There were only two justices that at least believe strongly enough that this case should have been heard by the Supreme Court to issue an opinion on it.
Okay, so we're basically, even with the appointment of Justice Gorsuch, we are not out of the woods yet. We'll talk about that in just a few moments. And yes, I do, when we return, I want to talk about the unusual aspects of the Peruta case that you are just talking about. In the meantime, we're going to take a break. You are listening to Wilmington's Big Talker, 106.7, WilmingtonBigTalker.com, and I am Paul Vallone, your host for Guns, Politics, and Freedom. In a moment, we'll take a short break, after which we will return with Professor Greg Wallace and charting the course of the Second Amendment in the courts. So please join us after this break for the next segment of Guns, Politics, and Freedom. My name is Paul Vallone, and you are listening to Guns, Politics, and Freedom today on Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com. Our guest today is constitutional law professor Greg Wallace, and our topic is the Second Amendment in the courts, what comes after Heller. Now, Greg, you were talking about specifically about the Peruta case that was just rejected by the Supreme Court as being one of the cases that deals with bearing arms outside the home. You said there were some particularly, I guess, some unusual aspects to that case. Tell us about that.
California had passed a law that ostensibly prohibited people from concealed carry in public. I mean, there were some very narrow exceptions. It was a lot like these other states' laws where you can only get a concealed carry license if you have some extreme need for it. But what that does is essentially for 95% of the people ban concealed carry in public. So that law was challenged, and in the three-judge panel that initially heard the case at the Ninth Circuit, they ruled in favor of those challenging the law. Well, while this litigation was pending, California turns around and also bans open carry in the state. And when the case goes back before the Ninth Circuit, the entire Ninth Circuit, again, the court was sitting in bank here. So you have a situation where California bans concealed carry for all intents and purposes because the exceptions are so narrow. And then you have, while the litigation was pending, California passes a law banning open carry. You have a result where people simply cannot carry firearms in public in California.
You couldn't actually, under that, from my interpretation of that, you couldn't carry your firearms to the range.
There might have been an exception to that, but I don't think so. I mean, this was a pretty broad type of law. And what the Ninth Circuit does, sitting in bank, and this is the decision that the Supreme Court declined to hear, but what the Ninth Circuit does is it says we're only going to consider whether the restrictions on concealed carry are constitutional. And we conclude that there is no constitutional right to carry a firearm concealed. Okay? The court says we're not going to address the larger context in which this statute operates with the other statute that prohibits open carry as well. Because the argument was, look, the Second Amendment protects public carry of firearms. And if you're going to essentially ban concealed carry, then you've got to let people open carry. If you're going to ban open carry, you've got to let people concealed carry. You can't say no to both and be in compliance with the Second Amendment.
So would it be fair to say that this decision you're saying lets them ban concealed carry because they can still open carry, but they can't open carry?
That's right. That's right. And the court refused
Only in California.
The court refused to consider the statute in its larger context, which means that they're going to have to file a separate lawsuit now challenging open carry on Second Amendment grounds. And they were hoping to get the Supreme Court to hear this case. The Supreme Court declined to do so, which doesn't mean that the court thought that the decision was correct. It just thought that it was not the right vehicle for another Second Amendment case here, over a strong dissent by Justice Thomas, which, as we said, was joined by Justice Gorsuch. But it's really incredibly stupid, and this is how these courts somehow treat these laws. Is that it was incredibly stupid for the Ninth Circuit not to consider this law in its larger context, because really what the case was, and this is one of the things that Justice Thomas points out in his dissent from the denial of cert, this case was really fashioned from the get-go as a case challenging restrictions on public carry in California. And it should have been treated like that by the Ninth Circuit. But the Ninth Circuit said, no, we're going to do this piecemeal. We're going to artificially separate the two types of carry. This case, we're going to interpret this case as only dealing with concealed carry, and we're going to conclude that concealed carry is not protected under the Second Amendment. But we're not going to think about this other thing of, well, are there then options in California to open carry And what are the effect is the denial of that on the Second Amendment rights of firearm owners in California.
My sister lives in California, and I really feel for her. She lives in probably one of the few conservative enclaves left in the state. And my nephew is a shooter, and I don't think even he understands what an oppressive system they live under. It's very sad and actually very deliberate, because if anybody wants to know what the left has in mind for the rest of us, they need only look at California or some of the other states. And, of course, they're not done with California either. These people will not be happy until they have banned the private ownership of firearms in its entirety. So, all right, the Supreme Court didn't take up this case. All right, now, once again, we've made a Supreme Court decision there. We've made a Supreme Court appointment. Donald Trump has that it was supposed to address this stuff. I mean, from what I can see, I love everything that Neil Gorsuch stands for. But what can we expect to see in the future? I mean, where do we go from here?
Well, the appointment of Justice Gorsuch really didn't get us any farther down the road on Second Amendment rights, because he was appointed to replace Justice Scalia. And so we still have ostensibly that same 5-4 majority in the Heller case, and that's and that's right, because you never know, for example, where Justice Kennedy is going to go with any of these types of decisions, and the liberal side of the court may be able to peel him off, as it has in other issues, to vote with them. So I'm not even sure that the Heller decision is safe, and that's why we really want the court to take the right case up there where Justice Kennedy is not, or even perhaps Justice Roberts is not going to peel off. I think the only three certainties that we have right now are Justice Alito, Justice Thomas, and Justice Gorsuch. So, it's kind of scary. I know there were a lot of people that were saying, while Justice Gorsuch, while there were only 8 justices on the court, we don't want to appeal any Second Amendment cases because we could get a bad decision from the court in that case. I think it's going to take President Trump one more appointment to get us sort of over the hump in that regard.
Ginsburg. She's old. Come on, she can go.
But the strategy,
I'm sure she's going to hold on for all she's worth in this administration.
I think so. The strategy of the anti-gun left has been to get incremental victories, and let's first of all ban those scary looking firearms, those AR-15s that look scary. We can confuse people, which is actually what one of the anti-gun proponents said a number of years ago.
Oh yes, what was his name? Josh Sugarman. Josh Sugarman. That was him. Yeah, I have that memo, as a matter of fact.
And now they're going after magazines for what they call large capacity magazines, which is any magazine over 10 rounds. Of course, as you mentioned earlier, that's their description of it. These 15 rounds are common among handguns, and 30 rounds, of course, are common with AR-15s. But they're doing this in increment. Now, California has a law going into effect just on July the 1st that bans the possession of magazines more than 10 rounds.
So now, for the first time, here we are. Forget grandfathering, forget all that nice stuff. Now we are actually confiscating gun-related accessories.
The people who own 30-round
without
magazines,
due process and without compensation.
The people who own those magazines have 3 choices. They can either move them out of state, they can sell them back to a federal firearms licensee, or they can turn them over to the police.
That is what the left has in mind for us in the future. I mean, they will do that with anything they can, and as much as I can look at California and say, well, they're a lost cause, but coming soon to a state near you, especially with Michael Bloomberg funding ballot initiatives and spending millions of dollars on advertising, as he has done here in the state of North Carolina on some of the stuff we're doing and hiring lobbyists. Well, thank you very much, Greg. We appreciate you joining us. I guess folks can look for your writings on the Hill, CNS News, National Public Radio.
the North Carolina media and elsewhere.
Yes.
And do you have a blog or anything along those lines?
I don't.
You should.
But one of my delights is to teach my firearms and the Second Amendment class over at Campbell Law School, and it's always heavily subscribed by the students. They're very interesting.
I want the
musicians.
Wallace conspiracy to come here in North Carolina. All right. My name is Paul Vallone, and our guest has been law professor Greg Wallace. You've been listening to Guns, Politics, and Freedom on Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com, where each Sunday at 5 p.m. as part of the Sunday Night Political Power Block, we give you the ammunition you need to defend your gun rights. I encourage you also to check our state's main gun rights organization, which I direct. It is grnc.org, grnc.org. Public radio, the North Carolina media and elsewhere.
Yes.
And do you have a blog or anything along those lines?
I don't.
You should.
But one of my delights is to teach my firearms and the Second Amendment class over at Campbell Law School, and it's always heavily subscribed by the students. They're very interesting.
I want the
musicians.
Wallace conspiracy to come here in North Carolina. All right. My name is Paul Vallone, and our guest has been law professor Greg Wallace. You've been listening to Guns, Politics, and Freedom on Wilmington's Big Talker, 106.7 WilmingtonBigTalker.com, where each Sunday at 5 p.m. as part of the Sunday Night Political Power Block, we give you the ammunition you need to defend your gun rights. I encourage you also to check our state's main gun rights organization, which I direct. It is grnc.org, grnc.org. grnc.org.